Greetings, Dr. Vijaya. My name is Isaac Lutz, and today I'll be presenting on why trustees are fiduciaries and the modern relevance of trust law. LexisNexis defines a trustee as an individual or company that is appointed to carry out the purposes of a trust. Trustees hold and safeguard the trust property and have a complex duties to perform. In Malaysia, the statute governing the trustees is the Trustee Act 1949. Lord Justice Millett, in the case of Bristol and West Building Society and Motiu, defines fiduciary as someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. In ISM Sindiran Berhad and Queensway Nominees Sindiran Berhad, when a fiduciary relationship does exist, the court explained that the scope of the duties and the nature of the fiduciary relationship differs in accordance to the situation. As such, fiduciary cannot be considered as a standardized bundle of obligation for each category of individuals. In Perman Sindiran Berhad and European Community Sindiran Berhad, the court had stated that all trustees are fiduciaries, but not all fiduciaries are trustees. This case emphasizes that a trustee will always stand in a fiduciary position due to their duties in managing the trust property for the benefit of the beneficiaries. Now, it begs the question, why are trustees fiduciaries? Trustees are fiduciaries due to their nature of duty towards the beneficiary. Firstly, trustees have a fiduciary duty to act gratuitously. This is based on Robinson and Pett, where Chancellor Talbot explained that a trustee cannot be compensated for his efforts and difficulty, as challenges might arise in determining or modifying the amount of the remuneration if a trustee is entitled for it. Thus, the general rule is a trustee must act gratuitously. When trustees act without remuneration, they are fiduciaries, as acting without payment shows that the trustees are to place the interests of the beneficiary ahead of theirs. When trustees are not compensated, trustees acting as fiduciaries have a less probability to be influenced by financial incentives in deciding how to manage and distribute the assets of the trust. This in turn ensures that the beneficiaries will benefit fully from the trust. Acting gratuitously includes not obtaining secret profits, such as bribes or hidden commissions. In the case of Islamic Republic of Iran Shipping Lines and Denby, a solicitor accepted a commission of $200,000 from the opposite side for securing the settlement of a legal action brought by his client. Justice Lagarde said what he received was quite simply a bribe, and he was liable to pay the sum to his client. This shows that trustees who have received such secret profits are liable to pay the beneficiaries of the trust fund the amount which they have profited from. The analysis of the case law shows that the relationship between trustees and beneficiaries is undoubtedly based on the principles of trust and confidence, which creates fiduciary duties. However, the general rule that trustees are to act without remuneration is not the ultimatum, as there are exceptions to the rule. Robinson and Pett further states that if there is a charging clause in the trust instrument, the trustees would be entitled to compensation. Section 46 of the Trustees Act 1949 is another exception, where the court may allow any trustee, aside from a public trustee, to receive compensation for his services, as the court may think fit. In addition, Aliff and Murray provided another exception to the general rule, in which a contract can be created for remuneration involving the trustees and all sui juris beneficiaries. Finally, involves the court's inherent jurisdiction, where in the case of Ray Duke of Norfolk, the court allowed an increase in the remuneration beyond that specified in the charging clause, because their duties had become unexpectedly onerous. Although these exceptions exist, trustees are fiduciaries, as the exceptions are permitted only under certain circumstances. Courts are not prepared to easily allow for trustees to obtain remunerations, unless they are in an onerous situation, as seen in Ray Duke of Norfolk. There is no automatic remuneration, and this does not disrupt the fundamental duties the trustees have as fiduciaries towards the beneficiaries. The rigidness of this rule ensures that trustees act gratuitously without any expectation of remuneration. Allowing compensation merely provides a sense of fairness from the trustee's end, and not towards the trustee obtaining a personal financial gain as a fiduciary. Secondly, trustees are fiduciaries as they are required to act impartially between beneficiaries. A trustee must not favor one beneficiary over another unless permitted by the trustee. In the case of Nestle and National Westminster Bank, the court emphasized that trustees have the duty to act fairly and impartially when making decisions that affect different classes of beneficiaries. However, it is not about treating everyone exactly the same. It rather means being fair and reasonable based on the circumstances. The aforementioned case affirms that trustees as fiduciaries should exercise their power fairly and without bias, and should have a sense of impartiality in balancing each beneficiary's competing interests in order to prevent any form of prejudice. A trustee who shows favoritism or fails to act impartially can be liable for breaching their fiduciary duties, rendering to financial damages and damage to their reputation. The fiduciary nature of a trustee to make discretionary decisions, free from any form of favoritism or improper motive, allows the beneficiaries to have continuous confidence over the trustee. Thirdly, trustees are fiduciaries as they have the fiduciary duty to administer and distribute the trust property in strict accordance with the set law's intention and the trust deed. In the case of Tetuan Kana & Co. and Saling bin Lau B. Chiang, the trustees were liable for failing to maintain proper accounts and misuse the trust fund of Rm 22 million ringgit. This case affirmed that trustees are fiduciaries because they are required to faithfully execute the set law's express intention and ensure the trust property is managed according to the trust deed. Any form of misuse is deemed as a breach of fiduciary duty. This case fortifies that trustees are fiduciary, as the trust deed can be considered as a form of tool to ensure that the trustees act within their powers as stipulated in the trust deed and not breach their fiduciary duties. This requires the trustees to act in good faith and have a sense of loyalty in upholding the set law's intention, rendering them as fiduciaries. Should the trustees be liable for a breach of trust or breach of fiduciary, they may rely on the defences such as Section 32 of the Trustees Act 1949, where trustees may advertise before distribution of property, which protects themselves from unknown claims. Other defences include, as per the case of Ray Benjamin, where if the trustees cannot find a particular beneficiary with all practicable steps, they can apply to the court for a Benjamin order, which allows to administer the trust on the basis that the missing beneficiary is dead. If the beneficiary then re-emerges, they have no action for breach of trust against the trustee. Although such defences exist, trustees as fiduciaries should act prudently in distributing the set law's properties in ensuring they do not breach their fiduciary duties. Finally, trustees are considered fiduciaries as they must not be in a position where their personal interests conflict with their duties to beneficiaries. In Gobachan Singh, Bhagawan Singh and Velusamy Pendusamy, Chief Justice Richard Malanjum stated, for a person to be a fiduciary, one must first and foremost bound himself in some way to protect the interests of another, which is an evident characteristic of the fiduciary office. The court further held that a company who served as a trustee is bound to protect and to advance the interests of the plaintiff, who is the beneficiary. It was held that a fiduciary relationship did exist between the company and the plaintiff, where the company as a fiduciary is obliged to act in the best interests of the plaintiff and to protect his interests. This case explains that if there is a conflict of duty, there is a risk that the fiduciary will deviate from his duty. The rule governing fiduciary, in which a trustee is one, is designed to mitigate such risks and promote the due performance of the fiduciary's undertaking. Another authority includes Dato C. Teo Chuan and Ui Woon Chi, where the court explained that it is tried law that the trustees who are fiduciaries should be financially disinterested when carrying out their duties, and that they must not put themselves in a position where their interests and duty conflicted, irrelevant whether any loss was suffered by the impugnant transaction. When a fiduciary does not have a conflict of interest, this in turn ensures the trustee's complete loyalty to the beneficiaries. Even if it is conflicting despite the fiduciary not of bad faith, a breach would still occur. This shows the strictness in making sure trustees execute their fiduciary duty with reasonable care and skill. Trust law remains relevant in modern Malaysia. Firstly, trust law is undoubtedly monumental in the commercial field. It can be seen in regards to unit trusts and other investment schemes. Unit trusts are defined as mutual funds and a form of collective investments that allow investors with similar investment objectives to pool their funds to be invested in a portfolio of assets. These portfolios may include cash, bonds, and deposits and shares. A unit trust is a capital market product and is governed by the Capital Market and Services Act 2007. In the case of 5-star Heritage Sdn Bhd and 9 Sararaj, where although this case concerned a charitable trust, it reflected how the Penang Burmese trustees, who has the power to manage the government bonds and unit trusts, are to ensure the trust property cannot be dealt with contrary to the wishes of the beneficiary. This Court of Appeal case emphasizes that trustees remain subject to equitable control and equitable oversight. Trust law offers legal recourse for aggrieved investors in the event the trustees fail to meet their obligations. This includes the beneficiary's right to demand an accounting of assets and to enforce the duties of the trustees. Although there could be an argument that commercial trust has deviated from the principles of trust law with the presence of digitalization and global financial changes, the core duties of the trustees have been preserved, and as such, a commercial trust still complies with the legal structure of trust law. Furthermore, trust law remains integral in the modern world with the application of constructive trust in disputes. President of the Court of Appeal Zulkifli Ahmad Makinuddin stated in Perbadanan Kemajuan Pertanian Selangor and JW Properties Sdn Bhd, the Api-Api case, where constructive trust arises by operation of law, whenever the circumstances are such that it would be unconscionable for the owner of the property, usually but not necessarily the legal owner, to assert his own beneficial interests in the property and deny the beneficial interests of another. The Federal Court had held that a constructive trust had been arisen between the vendor and the purchaser once the latter had paid the full purchase price and taken possession. This case highlighted as to how constructive trust may arise by virtue of a vendor-purchaser relationship. When a constructive trust is present, the court can enforce a claimant's beneficial interest in a particular property. This in turn protects their proprietary rights. As such, trust law, through constructive trust, is still relevant as it allows court to recognize equitable ownership and prevent unjust enrichment. Next, trust law plays a pivotal role in Sharia law, signifying its modern relevance. This is evident in Waqaf, which is a Muslim endowment that is recognized as an institution to provide public services for the advancement of the community. In Ismail bin Wahab and Majlis Agama Islam Melaka, the court held that the State Islamic Department has the power as a trustee to manage, develop, lease out and preserve the land, as well as to collect and distribute the revenue of the Waqaf properties to those who deserve it. This case explains how the trusteeship concept remains relevant, as both Sharia and trust law share the same fundamentals in holding property for the benefit of others. It can be said that trust law remains as fundamental as the need for a trustee to manage a Waqaf is a core component, and trust can serve as a modern framework for this purpose. Finally, modern trust law remains integral due to the wide application of the resulting trust principle. In Abdul Karim Pak Muhammad Seni and Tahir bin Yaakob, the Court of Appeal defines resulting trust as an implied trust, where the beneficial interest in property reverts or results to the person who transferred the property upon trust or provided the means of obtaining it. The doctrine of resulting trust is often applied in matrimonial property disputes. In Abdul Manap bin Ahmad and Versra binti Amun, the plaintiff had purchased an apartment to provide a place to stay for his mother-in-law, who is the defendant's mother. The plaintiff had included the defendant as the co-owner of the apartment. The purchase price of the property was paid solely by the plaintiff. At no time did the defendant contribute any monies whatsoever to the payment of the purchase price of the property. The court held that there was a resulting trust in existence in respect of the property to which the plaintiff was the sole beneficiary. This case emphasizes the modern relevance of trust law as it ensures fairness and justice in property ownership, particularly matrimonial properties. The scope of resulting trust may extend to cases of divorce or even when a dispute arises between the survivors and the beneficiaries. This shows trust law longevity in settling disputes in the modern world. In conclusion, trustees are deemed as fiduciary even if one is a bare trustee. When a trustee accepts office, trustees are fiduciaries in acting gratuitously, impartially, as well as distributing the trust property according to the trustee or settlor's intention, without any conflicting interests between and towards the beneficiaries. It must be emphasized that modern trust law remains highly relevant in the world we live in today. Its relevance lies in its adaptability and application, as its scope consists, yet not limited to, matrimonial disputes, commercial trusts, Sharia law, and property disputes, ensuring fairness and integrity in legal disputes.